Look good otherwise?
Yes.
All right, so I'll go ahead and print those, and then we'll come back at 1:15 for your closing arguments. Any other issues as far as what's going back to the jury during deliberations, the jury instructions, the defense exhibits? I don't think there are any state exhibits for the penalty phase.
No, sir. Everything was
Okay.
marked to the court today.
Very good. All right, so we'll go off the...
One moment.
Oh, wait. Just to be sure, or let me see what the defense has. It looks like they're pondering something.
Judge, may we amend the record relative to some of our missing witnesses? This might be at least a partial explanation.
Sure, absolutely.
Judge, I was informed, and again, as Mr. Burns said, just to clarify for the record, for purposes of appeal, should we get there, I learned last night in conversation with our witnesses and our expert that my client's ex-wife, Deborah Escalera, was essentially tampering with our mitigation witnesses and texting them or calling them and telling them not to come to court and not to testify.
Right.
So just as a background to why I think that, again, we don't have as many mitigation witnesses as we started with, that could potentially be a reason. I don't know if the state wants to flesh that out for purposes of criminal charges or what, but it has significantly impacted our ability to call witnesses in this case. I didn't know, I mean, there was the publicity issue, which we have talked about, and I think we've laid the record on that yesterday. But this is another wrinkle that I had not anticipated and did not know about until last night. But that person was specifically contacting our witnesses or potential witnesses, including my client's son, one of his sons, and telling them not to come.
So this is the first we've heard about this. My first question is, has any of this been reported to law enforcement, to your knowledge?
Not to my knowledge at this time, but that's not to say that it will not be.
Do you have any witnesses who could come in and provide sworn testimony?
Well, I think that matter probably is best left there between y'all. But
Okay.
given the nature of this proceeding and my review of the record in this case, I think most of what I've seen in the court file as far as potential mitigation has come out through the witnesses. However, there was a bond hearing that I reviewed. Judge Levin was the judge. It was when the case first started with Mr. Villafranco was the attorney. Damian Escalera, I believe, testified at that bond hearing. Just throwing that out there. It's a strategy decision whether you wanted to put it in the record before the jury. I believe you could. It was a bond hearing. The state, Judge Hendricks, who was a prosecutor at the time, was present. There were some other witnesses who testified in that bond hearing too. As I said, most of it was covered here. But just put that out there. There's a transcript in the court file of that. If you wanted to put that before the jury, you have the option of doing that, but that could also flesh out the mitigation.
I appreciate that, Judge. I think we'll stand on the record as it is now. I shouldn't want to do anything that might serve to highlight the absence of these witnesses to the jury.
Okay, and there again, it's a strategy decision. Even based on the content of what was said there, that's all. There's a tremendous amount of strategy involved in there. One of the witnesses who testified was Timothy Carroll, who was a pastor at Discovery Church. The defendant's a pastor at the time, but I understand it's putting that before the jury that could backfire in several ways. You know, that's a matter of strategy that the attorneys are well schooled on, trained on, as far as how far to go without going too far and not causing the wrong response. But just wanted to throw it out there because I did come across it in my review of the case before the trial, that bond hearing, which happened early. A lot of the witnesses who testified at that time were testifying under the strong belief of the defendant's innocence at that time. That did come out in the examination of them as well. So that's another factor probably the jury could discern from hearing the transcript as well. That would come out, and that's a double-edged sword as well. But I just want to throw that out there given the nature. The reason I do that too is if in the case laws you're probably aware of, in the cases where the defendant waives mitigation, it's the judge's burden to look in the case and do his own mitigation research. So along the lines of the habit of doing that, I noted that's in the record. But I think we all understand the dynamics of this, and the issue about the witness tampering and so forth. That's a matter left to the state to investigate as appropriate. And without further comment from me, that's not my place to do that.